Reservations to treaties, visualized. A reservation is a unilateral statement made by a state when signing, ratifying, or agreeing to a multilateral treaty that the state reserves the right not to abide by the treaty as a whole, by excluding or modifying the legal effect of specific terms of that treaty in their application to that state. A state's ability to make such reservations shows the principle of sovereignty of states, whereby a country may refuse its consent to particular provisions, so that they do not become obligatory upon it. The Vienna Convention on the Law of Treaties strikes a balance between the integrity of the treaty and the need for flexibility to encourage large participation of countries. On the other side, some treaties forbid or limit states to make reservations, like the UN Convention on the Law of the Sea and the International Criminal Court Statute. Otherwise, reservations are permitted unless the reservation conflicts with the goal and scope of the treaty. However, it's important to distinguish between those reservations that are contrary to the treaty purpose from those which are not. Two schools of thought have approached this issue. First, the permissibility school suggests that if the reservation is incompatible with the treaty, the approval of other parties is irrelevant. In contrast, if compatible, the parties may decide whether to accept or reject the reservation in question. While the opposability school considers the validity of a reservation as a matter of intention of other parties alone, and sees the compatibility test as a guiding principle. Lastly, a distinction is often made between reservations and interpretative declarations. Interpretative declarations are added by a state to the treaty at the moment of signature, ratification, or acceptance, to set out how that government understands a particular term in the treaty. In the Belailos v. Switzerland case, the European Court of Human Rights decided that a declaration made by Switzerland, when ratifying the Human Rights Convention, was a reservation of a general character and therefore not allowed under the terms of the convention. The court severed the reservation and held that the convention in its entirety bound Switzerland.